Hi everyone, I'm Smriti Bhaskar, Senior Research Fellow at the Center for Trade and Investment Law, and I'm joined by Professor James Nedumpara from the Center and Professor Leila Choukroune from the University of Portsmouth to discuss their new textbook on international economic law published by Cambridge University Press. Professor Choukroune is a professor of international law and the director of the University of Portsmouth thematic area in democratic citizenship. Professor Nedumpara is the head of the Center for Trade and Investment Law at the Indian Institute of Foreign Trade, New Delhi. He also teaches international trade law at Jindal Global Law School. They are both co-chairs of the South Asia International Economic Law Network as well. First of all, congratulations to both of you on your new book. I'm sure a lot of people are looking forward to delve into it. To start with, it will be helpful to understand what is international economic law.
Thank you so much, Smriti, and thank you so much for the invitation to discuss a little bit about our book. We're very happy to see you all wherever you are in the world. So good morning, afternoon, good evening. Excellent first question. What is international economic law? To simplify, I could tell you that this is the law of international economic relations. However, there is something slightly misleading or counterintuitive here, because when you think about international economic relation, you think about private sector probably. Trade, investment, businesses, yes, but our perspective is public international law grounded. So that's something really important to bear in mind. It is the law of international economic relation, but from the perspective of public international law. So we're going to talk about trade from an institutional angle with, for example, the World Trade Organization and all its agreements and instruments. We are going to talk about investment from also quite a state perspective, bilateral investment treaties between state and indeed other states. We're going to talk about development from, again, a quite statist perspective. So what the World Bank, for example, is doing to produce further development in given countries.
So thank you. I think I basically agree with what Leila mentioned. It captures broadly the international economic relations between the states. But at the same time, I would also like to mention that it also includes sometimes private actors. So think about a situation where a private, a firm or a company is exporting certain goods, and there is an allegation that the products are either subsidized or dumped exports. Then the other country can actually take an action. Sometimes this action are taken against countries, but individual firms are being targeted. So the international economic law actually provides a treaty framework in most cases, including the application of customary international law, which affects the relationship between the states, but there are internal participants within that as well. So in a way, that is why it has a very broad coverage. The subjects include the states, but at the same time, the key stakeholders are the individuals and the firms.
Thank you so much for a detailed explanation of international economic law. As you've noted, it has multiple themes under it. So does your book cover all of these themes? And sometimes these themes may be a little diverse. So how does the book sort of bridge between these themes? Maybe we can start with Professor James.
Yeah, thank you. That is a wonderful question again. In the field of international economic law, although the field is very vast and expansive, there are certain principles. So everyone might have heard about the non-discrimination principles, or what we call as the most favored nation principle and the national treatment. That principle has got eternal value. If you look at the domain of trade law or investment law, the national treatment or the non-discrimination principle is extremely important. Sometimes it also talks about the due process or maybe transparency requirements, like prompt notification requirements, consulting before a law is actually passed, trade facilitation measures. So there is a common thread, flowing across these kind of disciplines. So I'm not talking purely from a trade or investment point of view. This applies to international financial regulations as well, maybe to some of the new areas like the blue economy measures, environment for that matter. So there has to be proper information. I would actually like to recall the work of Lon Fuller. So Lon Fuller spoke about the rule of law and the 8 desiderata, right? And some of the elements are actually basically procedural. I think like clear notification, transparency, information dissemination, etc. So international economic law, to that extent, has got a number of commonalities. And that is why I said that there's a single thread going through all this area. And we have tried to capture it in terms of the treaty obligations, relating to these common areas, and how some of the disputes have arisen, specifically with respect to these disciplines and principles. So there is a coherent approach in this book by and large.
Well, I fully agree with James. I think there is great coherence in the book, which reconciles all domains of international economic law, from indeed trade, investment, development, finance, and what we've called new areas or at the crossroads, for example, environment and human rights, or indeed what we call today blue economy, everything which relates to the ocean or taxation. So the reason why it's quite coherent, there are probably two main reasons. As James explained, we have common principles between the different areas of international law. And one of the reasons is also, again, because it's grounded in public international law. So you have common principles. Also, our methodology is quite rigorous. Each chapter is constructed in the very same manner. So you have certain introductory remarks and questions. You always have boxes with case law, boxes with illustration, real life illustrations. You always have an exercise at the end of the chapter and some wrap-up question. So this sort of rhythm gives a lot of coherence and is making the reading easier for our readers.
Thank you so much. So you mentioned the structure of the chapter also. Was there a particular target audience you had in mind when you created the structure and when you structured the book, Professor Leila?
That's an excellent question. Thank you, Smriti. Well, we do have students' audience in mind, but not only. This is a book which can be used by practitioners, lawyers in firms, lawyers in government, but also a relatively general audience as well. I'm thinking about people working for civil society organizations who have, for example, to work on a human rights investment related issue. They're going to find a lot of examples and materials in our book. So it's certainly for students, most likely postgraduate students who've already studied international law, but not only, because we come from a varied background, and maybe James wants to add up on that. We are practitioners and we are scholars as well. So I think we've tried to blend these two elements in the book.
Yeah, I agree with that. I think, it is very difficult to crib and cabin the potential users of the book. Of course, I think as Leila mentioned, we have got a target audience, which is the international economic law community. And who is part of the international economic law community? The teachers, the students, the practitioners, the negotiators, the public officials, the judges, and the common man, because it affects the common man. And some of the kind of, I think, misinformation about international trade is because of lack of understanding. Who can actually quarrel with the non-discrimination principle, MFN, these kind of principles which actually bring in a huge amount of equality and fairness in the trading relationship between nations. So I think as academicians who are involved and deeply committed to this field, we have an obligation to explain the concepts in a clearly understandable language with the help of materials. And that we have actually done in this book.
Thank you. It sounds like it was a mammoth task to set about writing the book. So did you have any particular approaches that you wanted to include when you started with this? Maybe we can start with Professor James.
We have basically, when we really look at the discipline of law, any kind of legal law textbook should have a methodology or should have a method. And the method is basically to provide the basic text, because, Leila mentioned also that, we have got, some kind of a positivist approach to law as it is, right? So we have to provide the text, and then we know the text is not the only source of law. I think we have got the cases, the practices, the customary international principles, the general international principles for that matter. There are so many things which are actually part of this, the domain of international economic law. So we introduce each of these elements, the text, the case materials, the analysis, and we actually provide opportunities for students to think. And then we have got this kind of nice, tables and boxes in between, which provides a context. because we don't want to make this book an extremely boring book. And that is why we have given the life experiences as well. And at the end of the day, any kind of a learning or any kind of a pedagogical approach should have certain kind of questioning and responding to these questions in a methodical fashion as well. So we have got the exercises, the review questions, everything at the end of it. So I think we have followed a very clear method, and that method is consistent throughout the book.
Yeah, of course, I fully agree. So we have what we call a positivistic approach. So the law as it is, case law, legal text, agreements, etc. But we also blend that again with a critical approach and a theoretical approach. And I think something we really wanted to achieve is like twofold. We want the reader to critically think about what we said. And we also wanted to integrate global South perspective so that the book is not only based on, let's say, Western or global North experiences, because this is something we've noticed in, in the existing textbook in international economic law, but generally in international law, very often, if not always, they are based on global North realities. So this is something we really wanted to change for personal reasons, because we've traveled everywhere, we taught everywhere, we come from different backgrounds, and we felt that the dynamism you see today in the global South, in terms of norm creation as well, has to be reflected and understood.
Absolutely. Both of you mentioned case studies and maybe questions that are there in the chapter. So are there any unique features of your book that you think particularly students might find helpful? Maybe you can throw some more light on that, Professor Leila.
Well, yes, I think we alluded to that already, but I particularly like the real life stories we try to convey. So case law, real life case law, the banana saga, the WTO, the shrimp saga, or investment cases which have met the headlines, for instance, the Vodafone case in India, the Texaco Chevron case in Ecuador, real life stories affecting the people. So to some extent, it's a little bit the law from below. As James said before, international law and international economic law is not only for the diplomats and the lawyer, it actually affects everybody.
And Professor J?
In fact, Leila has actually given a very, I think, interesting flavor of some of the case studies that we have in the book. Rightly, we have got the banana saga, which I think, as an academic, when I started teaching this case, I really wanted to understand the bananas case, the GAP report, the bananas 1, banana 2, banana 3 for that matter, the compliance panel report, and it seemed like a never-ending saga of cases, right? And I still remember trying to, get a handle of this subject by reading multiple sources. So what we have done in this book is to try to give a 3-page summary of the case, what the case is all about, some of the critical issues. The same thing has been attempted in the case of the dolphin tuna case as well. And these are basically the watershed cases, the bananas case, the tuna case, the asbestos case, the seals case. And this book provides a very interesting, I think, and very interesting and I think adequate coverage of some of these landmark decisions and the kind of importance they have in shaping the course of international economic law, trade law, or investment law for that matter. So there are plenty of examples in the book. And I think that separates this book perhaps from some of its, I wouldn't say competitors, some of the cousins in this area.
Thank you so much. I think both of you have also mentioned that you come from diverse backgrounds with a long career. So could you give us examples of a unique perspective on a case or an area that was a result of your long career? Maybe we can start with Professor Leila.
Well, yes, I think James is going to say more about his WTO practice because he's surely one of the best world experts in trade law and certainly the best in India. But I can tell you a little bit about businesses and human rights, as I've advised a civil society organization NGO side, but also businesses. So I've tried to reflect upon that, very concrete business and human rights related issues, which are actually reflected in international investment law, for example. I've mentioned the case of Ecuador, Texaco in Ecuador. So we're talking about massive oil pollution in the Amazon region. You may have seen some documentary, some maybe a journal, newspaper, rather, articles on that. Well, this is again a real life story in which you have massive businesses, you have indigenous people, you have 200 lawyers, you have complex jurisdictions in Ecuador, in Canada, in South America. So I've tried to probably integrate a bit of my experience advising businesses and human rights in the book.
In fact, I think any kind of a publication, an academic publication, will have to reflect your own individual passion, your own thinking about a subject area. But a textbook has to be a very neutral document. It is not actually a document where you can actually write about your predilections, your predispositions, or your hates, or whatever. So we have actually followed a very, very neutral and objective approach to this book. But at the same time, sometimes in the Q&A session, we have actually raised a number of valid questions, and some of these questions touch upon some of the central areas of international economic law. To give an example, I think the carbon border tax adjustment is a very important issue. Whether it is a WTO consistent, some people say it is WTO consistent, others say that it is not consistent. Whether process and production methods can be used in trade or investment in order to differentiate either categories of goods or services or whatever. I think these are all problematic areas where there won't be any kind of unanimity or consensus between people, because these issues reflect the kind of I think divergent philosophies, divergent cultures, in fact. And we have raised these issues not with a view to seeking a final answer, but with a view to triggering a kind of a debate, because these are actually some of the I think long-standing issues in this area, and there won't be a final answer to it. So we have taken up these issues in the review sessions, in the mock exercises, and it is for the students to decide on which side of the spectrum they are.
Thank you so much. Maybe if you already explained what sets this book apart from maybe existing literature in international economic law, but is there anything else that you would like to point out that makes this a unique contribution to this field?
Well, yes, I think you're right, Smithy. We covered that slightly already, but I think 2-3 important features. It's objective, it's positivist in its approach in a way. So we do present the text, the cases, in a neutral manner, yet it's critical because we engage with the elements, the discussion, and we support and encourage students to equally engage critically. And it's diverse. As I said before, it's very much integrating all sorts of perspective, all sorts of intellectual perspectives, but also all sorts of country and people-based perspectives.
See, I think international economic law is actually going through a very interesting phase. So my feeling is that any textbook that's actually written in a particular point in time will need some kind of a revisiting and changes. And even our own understanding of some of these things will actually undergo a change. So my suggestion is that anyone who actually reads the book will have to actually help us in improving it, maybe for the subsequent editions. And international trade or economic, these are all, I think, issues which affect people in different ways. Globalization affects people in a positive way and in a negative way. And sometimes as academicians, we can only bring these stark realities for contemplation, consideration, and argumentation. And the students will have to basically bring forth, not only the students, anyone who reads the book will have to actually comment on it, and if they can bring to our notice, we will take them with all seriousness and then improve maybe in the second edition, but never forget to buy the first edition.
Absolutely. Thank you so much to both of you for taking us through the contours of the book and what went into its creation. I'm sure readers will find it immensely useful before they delve into the book. But to conclude, do you have any remarks or observations for potential readers of the book?
I don't have any particular thing. As I said, read the book with a certain amount of objectivity, and I think we have given enough materials that can keep you busy and engaged. And I'm sure that you would definitely love this field. And if this book makes you completely bored or disinterested in the subject, that is actually our failure. And I don't think that we have done anything to attract a failure. So go ahead and read the book and come with your comments and suggestions.
Yes, do come with us towards us with comments and suggestions, and do get the book, do buy the book, because it's a book that you can keep for your learning life. So it's not a book you're going to use only as a student, but probably you're going to use as a practitioner, as a civil society organization member, whatever you'll be doing in the future. These type of textbooks are written in a very long-term perspective. So this is a book you can keep, and that's such a very good investment.
Right. Thank you so much. I'm sure people are looking to buy the book, and I'm sure people will not be bored going through its content. Thank you once again. It was great talking to the both of you. Thank you.
Thank you, Smriti. Thank you for all your excellent questions. And thank you, Leila, again to see you and discuss about this book. Thank you.
Yes, and see you in real life very soon everywhere, Thanks very much, Smriti.
Thank you.